So, let's say an AI writes a hit song or creates a stunning piece of art. Who owns it? Who gets the check? This isn't science fiction anymore. In the age of generative AI, it's one of the most pressing legal questions on the planet.
To really get a handle on the future of AI and the law, we first need to talk about, well, a monkey. I know, it sounds a little nuts, but this is a real story about a curious macaw, a camera, and a wild legal fight that basically set the stage for everything we're dealing with today.
You've probably seen this picture before, right? It's the famous monkey selfie. And when it went viral, it kicked off this huge international debate. The question seems simple enough. Who owns the copyright to this photo? But the answer? Whoa. The answer turned out to be way more complicated.
So here's how it all went down. In 2011, a wildlife photographer named David Slater is out in Indonesia. A little crested macaque, later named Naruto, wanders up, grabs his camera, and starts snapping away. A hilarious, once-in-a-lifetime moment that, 4 years later, somehow explodes into a lawsuit that dragged on all the way until 2018.
This is where it gets really interesting. People for the ethical treatment of animals, you know them as PETA, actually filed the lawsuit. Their argument was pretty revolutionary. They said that since Naruto was the one who physically pressed the button, he was the author and should be the copyright owner. They accused Slater of ripping off the monkey and wanted the court to let them manage the money the photo made. All for Naruto, of course.
So, what does a court even do when someone claims an animal can own a copyright? Well, let's dive into what they decided, because this ruling sent shockwaves through the legal world.
The court's ruling was absolutely decisive. They said, look, copyright isn't about the simple mechanical act, just pushing a button. No, it's about rewarding the creative thought, the human intention that happens before the button gets pushed. And that one simple idea became a cornerstone of modern copyright law.
So when the court looked at it, they said neither side could really claim to be the author. Naruto the monkey, well, he obviously lacked that creative mental process. He was just playing around. But David Slater, who argued he set up the whole shot, the court said that wasn't enough creative input either.
And here it is, the key takeaway from the whole bizarre saga. The court drew a line in the sand. They established a firm human authorship rule. If there's no human mind making creative choices, there's no copyright. Period. Which means that famous monkey selfie, it belongs to no one and everyone. It's in the public domain. Okay, let's bring it back to AI, because that human authorship principle is right at the heart of today's debate. It turns out the rule that applies to a monkey also applies to a machine. Following that same logic, the U.S. Copyright Office has made its official policy crystal clear. They will only register a copyright for stuff made by people. A machine, just like our friend Naruto, can't be listed as an author. And this got hammered home in a huge court case that gave us this fantastic phrase. It said works created absent any guiding human hand can't be copyrighted. I love that. Basically, if a human isn't steering the ship in a really meaningful, creative way, there's no ownership to be had. So, you're probably asking, okay, how can I ever copyright anything made with AI? Well, it's all about how much of you is in the final product. You can claim copyright if you're the one who gives it that creative spark, and then you take what the AI spits out and really make it your own. You select it, rearrange it, or change it into something totally new. And this isn't just happening in the US. We're seeing a pretty solid consensus forming around the world. The US and the EU are both focused on human creativity. Canada's approach is a little different. They look for skill and judgment. But it's all pointing in the same direction. A human has to be the one calling the creative shots.
But hold on, because just when you think we've got a handle on things, the debate takes a sharp turn. We move away from art and copyright and into the world of patents and inventions. And this is where that global consensus just completely shatters.
Let me introduce you to Davis. It's an AI system created by Dr. Stephen Thaler. Yep, the same guy from that copyright case. His AI, Davis, independently came up with 2 brand new inventions. This forced patent offices all over the world to ask a totally new question. Can an AI be officially named an inventor?
Now, unlike the agreement we saw with copyright, the world is completely split right down the middle on this one. You've got countries like South Africa and Australia saying, sure, an AI can be an inventor. But then you have heavy hitters like the UK and the US saying, absolutely not.
So why the huge disagreement? It all comes down to how the laws are worded. In a place like Australia, the law never actually says what an inventor is, which leaves the door open.
But in the US and the UK, the law is super specific. It says an inventor must be a natural person, which is just legal speak for a human being.
And the U.S. courts, they have been incredibly blunt about this. In the Davis case, the Court of Appeals basically said, look, this isn't confusing. The law says inventors must be human beings. End of story.
So what this means is, for now, in places like the US and the UK, an AI is legally just a very, very smart tool. Think of it like a hammer, not the carpenter. It's used by a human inventor, it's not the inventor itself.
Okay, so with all these different rules and court cases, what does this actually mean for the future, for creativity, for innovation? Where do we even go from here?
0. That's the number. That is how many countries have completely figured out this incredibly complex puzzle of AI and intellectual property. Not a single one. Everyone is struggling with these questions, and the ground is constantly shifting beneath our feet.
All right, let's boil this all down to the essentials. First, right now, IP law is all about human creativity. Second, in the United States, an AI cannot own a copyright or a patent. Third, a person using an AI can be the owner, but only if they add a significant amount of their own creative juice. And finally, this whole area is a legal Wild West, and it's changing all the time.
You know, the fundamental problem here is that our legal systems were designed by human minds, for human minds. They were built to protect human creativity. But now those old laws are desperately trying to catch up to a technology that is evolving into something entirely new, something our laws were never designed to handle.
And that leaves us with one final massive question. Right now, we see AI as a sophisticated tool. But what happens when it becomes more autonomous, more independent, and maybe one day truly creative in its own right? Will our laws be ready for that?